You're about to read our first case where somebody is suing to vindicate their individual rights under the federal constitution. And I wanted to give you a little background before you get into that, both on how such suits can be brought and on the particular circumstances that surround Fuentes v. Shaven. So let's talk about how such suits can be brought first. What Fuentes is doing in this lawsuit is she's suing state government agents for violation of her federal rights. The reason she can do that is because of a statute called 28 USC, section 1983. What that provides is that every person who, I'm just going to read it out loud, under color of any statute of any state, in other words, anybody who is authorized by state law to do something or claims authorization under state law to do something, subjects any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights secured by the Constitution and laws. So, to translate, anybody who uses state law authorization or claims state law authorization to deprive someone in the United States, whether a citizen or not, of their rights under the Constitution and the federal laws. So the Constitution and laws here in this federal statute means federal laws. That person shall be liable to the party injured. So what this does is it gives a cause of action to the person who has been deprived of their rights. It gives them a statutory basis on which to sue. 28 USC section 1983 is called an act, or is labeled as an act to enforce the provisions of the 14th Amendment. You'll recall that the 14th Amendment is the amendment that extended the requirements of due process to the states, expanding it from just the federal government. And it did so in the wake of the Civil War. So it's one of what's called the Reconstruction Amendments that are aimed at giving rights and full citizenship status to the population of Black people in the South who had previously been enslaved. And one of the things that the 14th Amendment says is Congress shall have the power to enact legislation to enforce these provisions. And so there's a series of laws. We'll run into a couple of more. I think Section 1985 we deal with in just a couple of weeks. So there's a series of statutes that are aimed at ensuring that individuals have the ability to use and vindicate the rights that are granted to them under the federal Constitution, even in situations where their state governments may not be willing to allow them to do that, and where their state judiciaries may not be interested in helping them do so. So I think the alternate names for this statute kind of give the game away. So Civil Rights Act of 1871, that's the general enactment that Section 1983 is under. Its alternative name is the Ku Klux Klan Act. So 1983 is basically a response to white violence and white terror in the South against Black people who had been previously enslaved and were still living, obviously, alongside those who had previously enslaved them. So these statutes are an attempt to bring that previously enslaved population into the full ambit of rights and immunities that the Constitution grants to all citizens, and largely to all people living in the United States borders. So that's the point of 1983. It kind of federalizes these rights, and it gives people a cause of action in federal courts, so they don't have to go to state courts to try to vindicate these rights. Make sure that you understand, as you're reading Fuentes v. Shaven, which federal rights Ms. Fuentes is trying to vindicate. Okay, so all of that is for state actors. What about federal actors? What if a federal government agent violates my constitutional rights or some right I have because of federal law? Well, There is no statute that explicitly authorizes that lawsuit. Under a case called Bivens versus 6 unknown named agents, it's a 1971 case, the Supreme Court has recognized the possibility of suing for constitutional violations without a specific statute authorizing us to do so. But Bivens has been given very limited reach. It's mostly used only in the context of the Fourth Amendment and the Eighth Amendment. So search and seizure situations and deprivations of rights in prison, cruel and unusual punishment situations. And several current Supreme Court justices have basically said that Bivens shouldn't exist and we shouldn't even be doing this. So our right to sue state agents who violate our constitutional rights is inscribed in statutes, but our right to sue federal agents who violate our constitutional rights is basically hanging on by a thread under Bivens. There's no statutory authorization for that. Take a moment now and just think about how come the plaintiffs in Winter versus NRDC, the case you just read, how come they could sue the federal government? What allowed them to do that? And as you're thinking about that, and maybe even pause here and look back through the book to make sure that you understand why they could sue, just remember, you always need a basis to be able to sue. You can't just sue because you're unhappy. So in any situation, you got to be able to trace it back to something that authorizes the lawsuit, not just something that creates a legal obligation. Okay, so that's the legal background to Fuentes. Now I want to give you a little bit more of a general background to what's going on in that case. So, as you'll read about, Ms. Fuentes is someone who buys some stuff for her apartment, specifically a record player and a stove. Note that her apartment that she's renting does not have a stove in it, so she is buying her own stove. And she buys it on terms that should make your eyes pop. She buys a stove and stereo that are worth about $500, but she buys them under a contract under which she pays a monthly installment for them. And that includes over $100 of finance charges. So this is discussed on page 325. So she's paying more than 20% of the total cost of the thing she's buying in finance charges. Why would she agree to do that? Well, she probably doesn't have any other way of buying stuff, right? This is somebody without a lot of assets who has no other way of getting the bare life necessity of a stove in her apartment. And so she agrees to buy something on this contract system where she puts down a down payment or a monthly payment plus a whole lot of interest, a lot of interest. And that is normally how contract selling worked and works. Extremely high interest in fees because these sellers are working with effectively a captive population who can't go elsewhere because they don't have good credit, so they can't get a loan. Or there are other reasons that people can't get loans. I'll get into that in a sec. And they don't have the money up front. So under this system, as you'll see, the seller retains ownership until the buyer is paid off, and technically is obligated to maintain the product. You know, if you sell me a bum stove, you're supposed to, and you still own it, you're supposed to fix it. But the seller can repossess at any time if the buyer misses or withholds payments. So just think for a sec about the incentives that that creates for the seller who might not be that interested in maintaining Ms. Fuentes' stove, but can easily get it back if she says, I'm not paying for the stove that broke. It's important also to recognize that this contract system, this is not just for stoves. This is a really important way in which houses were sold specifically to Black buyers. And if you're interested in this, because this is really one of the roots of residential segregation all over America, there's some really fabulous studies that have come out, and I've put links up to all these books in course documents, talking about the way that specifically Black buyers who couldn't get a mortgage because the federal government refused to insure mortgages for Black homebuyers were basically pushed into the contract system for houses, just like Fuentes is for stoves. So what you're seeing in this case is a discrete legal issue, but socially speaking, this is a really widespread practice that actually underlies some of the way that, for instance, Buffalo is laid out today. So as you're reading Fuentes, you want to have a couple of things in mind. First of all, what is she suing about? What's the legal violation that she's alleging? Second of all, what allows her to sue about it? What gives her that cause of action? Third, drawing on the previous lecture, how do the relevant laws that are in play here appear in court? What is the court supposed to do with the statutes that it's addressing? And how does the hierarchy of legal enactments come into play here? And finally, what's the legal standard that the court uses? Where does that come from, and how does the court use it? So keep your eye out for what the court is applying here versus what the court is creating here. And you'll get a sense of the really innovative and creative process that is constitutional adjudication. Now, when you're done reading Fuentes, the notes here have some really important information as well. So as you're reading those notes, think about what is the current standard for determining whether a legal procedure fulfills due process. Is it still Fuentes? How does Fuentes relate to the current way that a court would figure out if something that a state agent did fulfilled due process?